Hey, everybody. Thank you for joining us on the Property Pros podcast. Today's guest is Stephen M. Bush, Esquire of the Bush Law Group. Stephen, take a couple of minutes. Tell us about yourself and your firm.
Well, first, Mark, thank you guys for having me today. I really appreciate that. I am a property insurance coverage litigation attorney, and I am licensed in 2 states, almost 3. We're working on the 3rd one now. But I have a law firm in Jacksonville that has attorneys who are licensed in a total of 10 different states. So we work all across the country. And the Bush Law Group just received an industry award this year for best law firm in the country. So we're very proud and honored to have received that award at the SVG Industry Awards in Dallas, Texas in February of this year. About myself, well, I used to be a contractor in South Florida for many years. My business partners and I were the #1 installer for a long period of time of Metro stone-coated steel. And so when you go out to Pembroke Pines and Weston and all in those areas, and you see all those stone-coated steel roofs that were Metro, those were probably roofs that we put on. And that was quite some time ago. But then I started to realize that the industry was making a change, it was making a shift. And we would get on, during those days, we could get on the roof with the adjuster, we'd show him the damage, he'd agree with us, we'd go down, he'd go to his truck, write us a check, we'd go in, hand the check to the policyholder, get another check cut back to us, and everything was over and done with, right? But then the industry started changing a little bit, and they started coming up with these unlicensed practice of public adjusting laws. And when that happened, I said, oh, we probably need to go get a public adjusting license. So I did. And when I went and got my public adjusting license, we opened a public adjusting firm, and that public adjusting firm became pretty successful. And we were handling claims in 3 different states at one time as a public adjuster. So I was a licensed public adjuster for 12 years in the state of Florida before I went back and became an attorney. But part of the reason why I went back to become an attorney was because I needed a bigger stick. The industry changed again. And when it changed again, I had to change with it, right? So my career, it's funny because over this 20-year span, my career has continued to grow as the market has changed. And as the industry has changed, I've had to adjust and adapt and change with it. But no more changes. I'm done. I'm an attorney now. That's good enough. And I'm getting to that stage now where it's not too far from retirement. So no more school, no more changes for me. I'm getting old and set in my ways.
But the industry keeps changing, just like it did back then, to cause you to do something else. Every year, they come up with another crisis, more reason for lots of legislative changes. And they're putting last 2 years, they've been putting the squeeze on attorneys.
They really have. And you're exactly right. The industry is changing again. And just since I've been practicing law, we've had to change the way we practice law and the way we handle cases because of the shift and the changes in the industry and the way that the carriers are having the defense attorneys litigate the cases. Now, in the beginning, when I first started practicing law, when you filed the lawsuit, they'd file their answer and then they'd call you and say, okay, let's just talk about this. Let's figure this out and let's work through the issues, right? We would work together and then we would get some things resolved. And then they say, okay, let's go to mediation and we'll be done. All right. So we'd go to mediation, we'd settle the case, and they would actually come to the mediation with money. You know, they don't do that anymore. They come with $5,000 now, and that's all they come with. But back then, they would actually have money and they would offer you that money at mediation and not hold it back. And we could get claims settled. But the industry, again, like I said, shifted. So we had to shift in the way we were practicing law. So now, in today's environment, it's a lot more aggressive. The carriers and the carriers' attorneys have become extremely aggressive and litigate the crap out of these cases. And when I mean litigate the crap out of them, I mean they litigate them to the hilt. And there's going to be, I think, another shift in Florida. Now, like I said, we practice in 10 states. So one of the states we practice in, Georgia, well, that's always been heavily litigated state since day one. they just litigate them to death in Georgia because they know there's no fees, and there is also no bad faith. There's no laws that really favor policyholders. So the defense attorneys from the beginning just litigate them to death so that they can bill the carrier. And that's what's happened there. Virginia, another state where they're litigating quite heavily again. North Carolina, not so much. You can still work through claims in North Carolina. And most of what I find from opposing counsels in like North Carolina is that they are more willing to, more hometownish, more good old boy. So if you just treat them right, they treat you right and they'll get things settled. Texas, we've opened an office in the Dallas-Fort Worth area recently, and I'm finding that the defense attorneys in Texas are litigating them a lot like Florida, because we know Texas and Florida together, those two are the most heavily litigated states in the country. So things are changing a bit, and we are still having to adapt. That's true.
You know, we find that we've had to adapt ourselves. What can you speak about in terms of the adaptation that you've done? I mean, explain it to people that have no idea what you do and how you do it, how it's changed and made it more difficult for people to get what they're owed.
You mean as a from an attorney standpoint, or just from an overall standpoint?
I mean, maybe a little of both. You can explain your standpoint because that's what you do. But I mean, from a consumer standpoint, if we just had regular business folks that come on here and watch this show, what do they have to deal with if they want to file a claim because they had damage to their property?
All right, and that is, Peter, that's such an excellent question. And that is probably one of the most important questions that could have been asked the whole time that we're doing this. Because when a policyholder has a claim now, they have to be very careful what they say. I'll give you a great example. I actually have a case where we just got through with an examination under oath of a simple water loss. A simple water loss. The wife took a shower. She turned off the shower. She dried herself off. She got dressed. And as a matter of habit, she goes into the shower and she always wipes the floor down. Why? I don't know. That's just what she does. Well, she noticed when she wiped the floor down this time that water kept coming back. All right. First time she noticed it, she called her husband in. They took a photograph with a date stamp. They called in the claim the day after. And when they had their recorded statement, which was 2 weeks later, she gave wrong dates. She gave misinformation. So the carrier's hanging their hat on that one issue that she doesn't know when the loss occurred. She does know, right? So this is what I'm saying. If you have a loss as a policyholder, make sure you have your facts together, that you know what's happening with your loss, and that you can prove those dates up front. The second thing, policy information. You've got to know what's in your policy, because you have to know what to say. Mark, you know this, and you and I have had this discussion before. Policyholders will immediately say, we have mold. We have a mold loss. We have a mold issue. Well, you don't have a mold loss. Nobody has a mold loss. What do you have? You have a water loss. Why do you have a water loss? Because what comes first? The water. Water comes before mold. You can't have mold without moisture, right? What's covered under the policy? A water loss is covered under the policy. What's not covered or limited in coverage? Mold, right? So immediately policyholders will go and say, oh, we've got mold. And then carriers hold on to that. They hold on to that. And then they don't pay these claims, knowing darn good and well that they owe it. And they owe it because they know that they owe it based upon the terms and conditions of the policy, but they're refusing to pay it just because of something that was said. So if you're a public adjuster and you're on site before a claim is called in or before a recorded statement is given, make sure that you're talking to your clients and you've got them saying the correct things. Now, I'm not telling you to have them say bad information or things that are just flat out wrong. All right, we can't go there, but they just need to make sure they know what's happening and when it happened and how it happened, so that they can say those things that the carriers don't grab a hold of, right? And then they hold on to those things all the way through litigation, which brings me to what happens when it comes over to me. All right, you guys can't settle a claim. You bring it to my office and we look at it and we say, well, this should have been paid. So all during litigation, it's the same song and dance. And that song and dance is, well, it's mold, it's a mold loss, it's a mold loss, it's a mold loss. And we're going, no, not a mold loss. Look at the policy, read the policy. And then through motions and then, other court appearances and then getting depositions of experts. And now we've spent tens of thousands of dollars. We finally get to the place where they pay the loss. When they should have paid the loss, when? A year and a half ago, they should have paid the loss. It should have never come to me. And this is what's frustrating about the industry and what's going on today. You want to know why carriers are going bankrupt? Because they're not paying legitimate claims on the front end, and they're creating more expense on the back end, which is why they're going bankrupt. If they'd have just paid the claims that they owed and paid them at a decent amount, they didn't even have to pay them at the full amount, just pay them at a decent amount, but they're not even doing that. And they're forcing everybody into litigation. And when you force people into litigation, of course, all the expenses go up. There's nothing more you can do. So that would be my advice, is just make sure that you got things teed up and you're saying the right things, and you got accurate dates and who did what when, and you have a good timeline, a baseline of what happened.
I guess that policyholder who gave that statement with the inaccurate facts about the date of when it occurred was not represented by anybody at the time that she gave that statement, right?
She was represented by a public adjuster at the time.
Uh-huh.
But again, and I don't blame the public adjuster in this instance, because he actually had all the facts. Just when she gave the statement, she got confused. And when she got confused, she started saying, well, I don't know, I don't remember, those types of things. And the truth of the matter is, if she'd have just taken a deep breath and got herself together and started over, she probably would have been all right. But they've created this scenario now where the carrier is not paying because they're holding on to the fact that we don't know when the date of loss was. And we do know what the date of loss is.
Very antagonistic. I've had that on the last few recorded statements. I've been doing this for 9 years. It was never that way. When we first started, they were just, wanted to confirm a couple of bits of information. I've had them a couple times in a row where they ask leading questions to try to trip them up in their answers and answer it in a way that allows them to decline the claim. And I just interject and say, I don't think they understand the question. Let's clarify what you're asking before they answer.
And that's excellent. In examinations under oath, we're not supposed to object or interject in any way whatsoever as the policyholder's attorney, but I always do. If there's ever a situation where I think that it wasn't clear or the answer given wasn't correct, I will say, hey, listen, I don't think she didn't understand you or whatever, because she didn't give you the right answer. And then they always are like, well, you can't say anything, da, 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 da. My response always is, and I've never had one say anything different to me when I say this. Now we're on the record, right? So I say, well, the whole purpose of an examination under oath is to help you get accurate, truthful information. I'm telling you that the information you just got was not correct. Are you telling me that you don't want correct information?
And they love it.
What are they going to say? What are they going to say? And there's like, and usually, well, what do you mean? What do you mean? I'm like, okay, here's the deal. Explain to him, and then I sort of take over the examination under oath, and I start questioning my client, right? Because I know what's going on. So I'll start asking questions, and then I'll turn it back over, and I say, okay, now you can finish. And right. Usually they let that happen, and you should be doing that too. So good for you for interjecting. You should be doing that. Making sure that the record is accurate. That's the key. The record has to be accurate. We can't let bad information get on the record, because when you do, it causes problems on the back end, right? And problems on the back end create situations where we have to go to litigation. Whereas if they would just let you get it right on the front end. But let me ask you this, Peter. Do you think they want accurate information? Why do you think they're giving leading questions in the first place?
Well, you and I know that answer. I mean, the people that might watch this video don't understand that, but we know that. And we understand the songs and the propaganda that's being put out there. And they cry that we need more money for our premiums and it's costing us this. So we increase the premiums, the net bottom line to them is higher, just as when fuel prices rise, the oil companies make more money. So I mean, it's
Yep. Well, now I'm not, I don't want to discount the fact either that, that reinsurance is I think another big issue in the market in Florida. And that's a whole nother topic. That's also causing a lot of issues. But listen, carriers mishandling insurance claims on the front end is the number one problem that we have in every state that we work in. And that is why they're losing money, and that is why they're closing their doors. It is because of mishandling insurance claims on the back end. And to me, what I think is their thought process is, if we put people who are ignorant about what to do, about what to say, about how to handle these claims on there, then we won't have to pay claims, right? So we'll save more money. But what they're failing to realize is that the consumers are more intelligent today than ever. Why? Because we have the internet, right? And so that's why litigation is up, because these people, they're going online and they realize, hey, you know what, you do owe me money. And then they're going after it to try to compensate for what the failure of the carrier on the back end to do what they're supposed to do. They need to spend more time training up these adjusters and training them to do the right things on the front end, and they wouldn't have all this trouble on the back end.
Yeah. I've long said that the best trained adjusters in all of insurance are in their fraud units. That's where all of the training, and coming from that background, I know that to be true. That's where the people who, the best and the brightest from the insurance companies go into their fraud departments, their SIU units, which they're not there to pay claims, right? They're there to uncover fraud and again, leaving, the bottom of the crop to handle the claims or mishandle the claims. And I know we just settled the longest claim that we've had open. This insurance company drug this out from, the claim was in 2015 and it just settled. It's been in litigation for over 3 years and didn't go to trial, but settled. And we're talking about a simple claim, less than $20,000. You can imagine what they paid to the attorneys on both sides. And they thought that that was the better way to go.
Now, see, on a $20,000 claim, the minute that complaint hit their desk and they filed an answer, they should have been on the phone with the plaintiff's attorney trying to get rid of that case. Because you're exactly right. I'm willing to bet you 3 years in litigation, I'm willing to bet you that they paid 3-4 times that dollar amount to the defense attorney, when in fact they could have just gotten it all over with and saved themselves a bunch of money on the front end. But they didn't. And this is a great example of why we have the issues we have today in the insurance market. It's because of mishandling these claims. But that wasn't with my firm, was it?
No, it wasn't. So Stephen, before we started recording, we were talking a little bit about, you've got some cases coming up for trial. And I can tell you from our end, in almost 18 years, we've only had 3 cases go to trial, none in the last 5 years, at least 5 years since our last claim went to trial. They all get settled before they go to trial. What are you finding that's different to where you're actually taking cases, you're seeing more cases being brought to trial?
That's a good question, because the cases that we're seeing going to trial should not be at trial. They're a waste of the court's time, judicial efficiencies. It's crazy. These are absolutely cases that should not be tying up the court, and they are. And I'm not sure why carriers have decided to force them all the way into trial at this time, because I currently in my office right now, I have 8 cases at one time going to trial. And that's just incredible for one firm to have that many cases going to trial, especially at my firm size. Because, we're still a small firm, but to have 8 cases that are absolutely going to trial is unbelievable. And many of those cases, the defense attorneys have done nothing. The insurance companies have sat on their hands through the entire process and have not engaged in litigation. And we've just been marching it on right down the line. And these cases are on a case management order. All 8 of them are. So we have definite trial dates. And we've just been marching it on, towards trial. And the defense attorneys are doing nothing. Now, if you'll remember, there was a time when State Farm and Allstate decided that they were going to try everything. They were going to just show attorneys and show policyholders and public adjusters who they were. They were going to flex their muscle, right? And they were going to take everything to trial. And they were going to challenge everything in the courts. If you look at most of the appellate decisions and most of the Supreme Court decisions, who's the #1 insurance company in every case? Who is it? State Farm. State Farm, right. So they took that position, right? So I'm just wondering if these carriers now, like Universal, Heritage, ASI, Progressive, Olympus, Tower Hill, Citizens, all of them are taking that position now of let's just move things to trial. And I'm not sure why they're taking that position. It would be one thing if they had good, solid cases, if maybe the policy language was in their favor, or maybe they had facts that were in their favor, but they don't. They don't. And I'm talking to other plaintiffs' attorneys because I want to know what their experience has been at trial. And I can tell you, I can name you 6 plaintiffs' attorneys right now who've all been to trial in the last 6 months on cases when they didn't go to trial for 3 years, 4 years before, because of carriers pushing things towards the trial. Now, what happens when they push these cases to trial? And by the way, they've been losing. They've won 1 or 2, right? 1 or 2. What is it? My granddaddy used to say, even a blind squirrel gets a nut every now and then.
Yeah.
All right. So they've won 1 or 2, but they've mostly lost them all. So now let me ask you, what happens when you go to trial and you lose? Who pays?
They do.
They do. So now what happens to expenses? Through the roof, right? Another mishandling of their profits. And I don't know. I don't get it. But hey, you know what? It allows all of us to have a great job protecting policyholders, and I'm not complaining. Believe you me, I'm not complaining, because I love the courtroom. That's where I think I do my best work, is in the courtroom. But it bothers me as a business owner and as a consumer to see insurance companies literally mishandle their business and then cry a foul that it's my fault and it's your fault as a public adjuster that they're going out of business. It's not my fault that they're going out of business. It's their fault for not taking care of their business, and that's what they ought to be doing.
I think that's a dirty little secret. They talk about how bad people like you and I are, but they don't realize they're getting fleeced by their own experts and their own attorneys who have no interest in actually settling these cases. But Stephen, thank you so much for being a part of this podcast today. We're really glad that you came on. Do you want to let people know how they can get in touch with you in your office?
I do. And I appreciate you guys again letting me be a part of this and asking me to join you today. All right. So it's the Bush Law Group. You can find us at bushlawgroup.net, or you can call us here in Jacksonville at our offices. But we handle cases in pretty much all of the Southeast, 10 states. And I will tell you now, I have handpicked the attorneys that I have in my office, each one for their strengths. So what I've tried to do is build a firm that is strong in all areas, not just in one area. And we all support one another so that we're I tell them all the time, let's don't be good, let's be great. And I think that's what we built at Bush Law Group. We built a great law firm who's got a great reputation, evidenced by our industry award. And we're continuing to do great things. And you can get us like I said, online, bushlawgroup.net, or either call us at the Jacksonville office, one of the two. But again, guys, thank you so much.
Well, thank you, Stephen, for joining us and taking the time to visit with us. We really appreciate it. Folks, we appreciate your tuning in. If you'd like to check out some other episodes, you can find us at Property Pros Podcast on Facebook or on YouTube. Thanks until next time. We'll see you later.